Good afternoon and welcome to the final webinar of our three-part series providing an overview of the key aspects of construction contracting relating to payment, variation and time. This series aims to highlight best practice in relation to these aspects in order to work efficiently and avoid disputes where possible. Today's webinar will focus on issues of time in construction contracts, including programme requirements and management, and also extension of time claims. If you'd like to ask a question, please do so by using the Ask a Question tab. In order to keep within the time, we'll be answering as many questions as we can at the end of the presentation, rather than as we go along. If you don't manage to get to your question, or if you are listening to a recording of this webinar, Lisa and I would be happy to address any queries after the webinar by phone or email. Our contact details are noted on the next slide. So your speakers today, I am Gregor Hayworth. I'm an associate in the Commercial Disputes team at Shepherd and Wedderburn, specialising in construction, infrastructure and energy disputes. I'm joined today by my colleague Lisa Ambrus, a solicitor in our team who also specialises in contentious construction. As dispute specialists, we have an up-to-date understanding of the legislative, court and industrial context. We also have a strong commercial focus, all of which forms the basis of which we will share with you today. I'll now pass you over to Lisa, who will run through the agenda for today's webinar.
Thanks, Gregor. We will start by looking at programme requirements and management in both JCT and NEC contracts. We will then take a closer look at how JCT and NEC deal with extension of time claims, building on the information in our second webinar on variations and compensation events. After that, we will then have a look at some complex but key time concepts, namely acceleration, critical delay analysis and concurrent delay. Finally, we will conclude with some best practice tips and advice on how you can manage programmes and time events.
So let's start with the basics. What is the role and function of a programme? Put simply, a programme describes the sequence in which tasks must be carried out so that a project can be completed on time. Its key function is to ensure the effective sequencing of the various components of the work. However, as we discuss later in the webinar, it has a dual and complementary role in forming the basis of additional time claims. A programme will identify dates and durations to be allocated to tasks. Most programmes will also identify what is referred to as the critical path. This can be defined as the shortest time in which the works can be completed. The critical path is made up of the tasks on which the overall duration of the programme is dependent. A delay to one of these tasks will delay the completion date. Therefore, these delays are called critical delays. Not all delays are critical delays because not all delays will affect the completion date if that particular task can be accommodated out with the critical path. Primarily, it's only critical delays that will be relevant to an assessment of the contractor's entitlement to an extension of time. In our experience, for a programme to be most effective, it should not simply be used as a record of what has already happened or is likely to happen in the future. Instead, it should be used as a contract management tool to help plan activities, monitor progress, and identify problems as early as possible. A properly constructed programme is also essential for the contractor to demonstrate an entitlement to time. The different suites of standard form construction contracts have different provisions regarding the management of the programme and vary significantly in terms of how onerous their requirements are.
So the first suite that we will discuss today is the JCT or SBCC suite of contracts. As always, we use these terms interchangeably as SBCC is the Scottish equivalent to JCT. Please note that we will be focusing on the 2016 suite today, and if you are using a previous version, you may find some differences. It is also important to note that we are discussing these conditions in their standard form without any amendments, and it is common practice for these clauses to be adapted to the needs of parties. Standard form provisions and programmes also vary according to the particular form of JCT contract in use. The JCT standard building contract does contain some provisions regarding the management and upkeep of the programme. Section 2.9 requires the contractor to provide a master programme to the architect or contract administrator following execution of the contract, if that has not yet been provided. If the contract particulars require it, this must identify the critical path. Where there is an agreed extension of time, within 14 days of the decision by the architect or contract administrator, the contractor must provide a revised master programme to take account of the decision. This programme will not impose any obligations beyond those in the contract documents. In contrast to the standard building contract, the design and build contract does not deal with the provision of programme information. This approach is largely consistent with the nature of works carried out using design and build contracts, as flexibility in programming is often required. However, the employer may still require access to programme information in order to assess extension of time claims. Therefore, it may be that parties wish to adopt the procedure outlined in the standard building contract or operate a system with joint access to the contractor's programme. It may be helpful to incorporate provisions on management of the programme into the contract documents, for example, in the employer's requirements, rather than by amending the terms of the conditions, in which case it is important to ensure that the relevant technical parts of the contract documents provide the detail required.
The second suite of standard form construction contracts we'll look at today is the NEC. As with previous webinars, we'll be focusing on NEC 3 today, as we still see this suite of contracts being the most commonly used. However, many of the provisions are similar in NEC 4. In comparison to JCT, NEC has relatively strict requirements for the management of programs. A preliminary point to note is that there is a difference in the program between the contractor's start date and the contractor's access date. Therefore, there might be quite a lot of activities that are required before the physical works start on site. You cannot start work on site until the access date, however that could be sometime after the starting date. Initially, the contractor must submit a program to the project manager for acceptance within the period stated in the contract data. There are sanctions if the contractor fails to submit an initial program. At clause 50.3, the employer can apply a 25% retainer on payments to the contractor for work done until there is a program in place. It's not explicitly clear that this requirement falls away once the first program has been submitted for acceptance by the contractor, or whether it only falls away once the program has actually been accepted by the employer. Therefore, any delay in submitting an initial program should be avoided if possible. This program and all subsequent programs need to be relatively sophisticated. Clause 31.2 sets out a specific and detailed list of the items that must be built into the program, which include the start date, access date and planned completion date, the order and timing of the operations of the contractor and employer, details of the resources and equipment to be used for each operation, dates by which the contractor will require access or specific information, for example design information, and provisions for float and time risk allowances. If the program is included in the contract data, then it is automatically deemed to be the accepted program. If the program is submitted afterwards, or there are any revisals to the program, it will only become the accepted program after being accepted by the employer. Clause 31.3 specifies allowable reasons for not accepting a program, which are the program demonstrates that the contractor's plans are not practicable, the program does not show the information which the contract requires, the program does not realistically represent the contractor's plans, or the program does not comply with the works information. You'll note that these reasons are relatively subjective, so the balance of power is somewhat in the employer's favour. So what happens if the program is rejected? Well, the contract is actually silent on that. By default, the previously accepted program will continue to be the contract program. But if there was no program in the first place in the contract data and the contractor does not accept the first program, then there is an important contractual mechanism missing. There's nothing to stop work starting without a program, but there will be some knock-on implications. If the project manager does not accept a program for any other reason than listed in the contract, then this rejection can be challenged and is likely to be a compensation event under clause 60.16 or 9. The program cannot be rejected simply because completion is shown as later than the completion date. However, there is no easy way of forcing a project manager to accept a programme, and compensation events are generally complicated, time-consuming and costly. As may be obvious, it is always advisable to maintain good working relationships and have open discussions about the reasons for the rejection of programmes, as it is clearly important to get an accepted programme in place as soon as possible.
The accepted programme should also show any float. Float is essentially leeway built into the programme to allow for any delays or problems without delaying the overall completion of the works. Float is calculated by subtracting the time necessary to perform a task from the time available to perform it. You can have total float, terminal float, or time risk allowances. Total float is the time a specific activity can be delayed from its early start date without delaying the planned completion date. Terminal float is the difference between a contractor's planned completion date and the completion date set in the contract. And time risk allowance is the amount of time allowed by the contractor in programming individual activities for the risk of delay should problems arise. This can be for risks such as poor weather and inefficiencies on site that have a reasonable probability of occurring but are not significant enough to merit inclusion in the risk register. If the contractor has built time risk allowances into their programme and a float for particular activities, and a compensation event has an impact on the critical path, they do not lose the float. Indeed, building float into a programme is not a reason for the project manager to reject the programme. This is not to say that the contractor would not be under commercial pressure to remove the float. However, the contractor is entitled to resubmit the programme on the basis that the rejection was not valid. So, when must the contractor submit a revised programme? A contractor can submit a revised programme whenever they choose, and can also be instructed to submit a revised programme. In any event, this interval should not be longer than what is stated in the contract data. Even though the contractor may revise their programme whenever they choose to, this does not lead to an automatic change in the activity schedule. However, it is a positive habit to update the programme every time there is a change. Failure by the contractor to submit revised programmes is of considerable disadvantage to the contractor, as if a compensation event occurs, the project manager may assess it based on their own assessment of what the programme should be under clause 64.2, which can have a negative impact on time claims. On that note, let's now move on to a discussion of additional time claims.
So, in general terms, if a contractor does not meet the specified completion date for the works, or indeed a defined stage of completion, liquidated damages will be applied until completion is achieved. One of the crucial impacts of an extension of time claim is therefore to relieve the contractor from this liability. All of the standard form contracts contain broadly similar provisions defining the circumstances in which an extension of time is to be granted. In JCT contracts, extension of time awards come under the term relevant events. These are events that cause delay to works and entitle the contractor to claim an extension of time resulting in an amended completion date. Relevant events include variations, for example, by way of employer's instructions, and also factors within the control of the employer, such as delay in access to the site. However, it also includes neutral events such as adverse weather conditions and loss or damage caused by a specific peril. If such an event occurs, the contractor will be awarded an extension of time, but may not receive any additional funds to cover the cost of being on site for longer than planned. The impact of the extension of time award is that the contractor will be exempt from any liquidated damages provisions that might have applied if the original completion date was not met.
In contrast with JCT, under NEC, all time and cost events are referred to under one broad category called compensation events. The concept of the accepted programme, which we discussed earlier, plays a very significant role in additional time claims in NEC contracts. Submitting a revised programme does not in itself constitute an application for an extension of time. However, the accepted programme should, at any given time, be the contractor's realistic and practicable plans for completing the works. Clause 32 states that the contractor should include any other changes that it proposes to make to the accepted programme, which should include the forecast effects of any known delays and compensation events. When assessing an application for additional time, the starting point is the latest accepted programme. Under clause 63.3, it is necessary to identify the length of time that due to the compensation event, planned completion is delayed against the latest accepted programme. The contractor must identify which of the 19 specific compensation events listed in clause 60.1 that the event relates to, and then the process of notification, quotation, assessment and implementation, which we've outlined in our previous webinar, should then be followed. Let's move on to some of the more slightly complex timed concepts. Please note that this webinar simply aims to bring attention to these concepts, rather than provide a detailed analysis of the law applicable to each of them.
So, in our discussion of time events, it is worth noting acceleration. This term is used to describe a variety of different concepts, sometimes describing the process of speeding up to meet the current completion date if there's already been delays to the project, or of speeding up to complete earlier than the specified completion date. It is the second scenario that is classed as contractual acceleration under a JCT or NEC construction contract. In JCT 2016, Schedule 2 deals with acceleration quotations and specifies that the quotation must identify the amount of time that can be saved and the amount of the adjustment to the contract sum that the contractor requires to achieve the earlier completion date. It must include direct costs, consequential loss, an expense and an allowance for the cost of preparing the quotation. With regard to NEC contracts, the process is similar to the JCT, with the contractor submitting an acceleration quotation stating the impact of the acceleration in terms of time and cost. The completion date will then be the completion date as amended. This is important to note, as if the completion date has been pushed out by a compensation event, particularly in a power project with a critical deadline, contractors may still be pressured to achieve the original completion date. However, under an unamended NEC contract, there is no requirement for that to occur. Contractors may, however, be liable for liquidated damages if the completion date is not going to be met without the benefit of a time compensation event. When NEC contracts are amended and move away from the NEC principles, there are times where acceleration can be forced on the contractor. In those circumstances, a better way of thinking about acceleration is as a compensation event. In our experience, it is important not to accelerate until an acceleration quotation has been accepted. Contractors should be confident in saying no if they do not have the resources or the ability to accelerate. In particular, contractors should also decline to accelerate if there are other issues that are causing the delay, as this can result in issues quickly becoming intertwined and difficult to unravel. This brings us neatly on to a discussion of critical path analysis and concurrent delay.
So, as we discussed in the first part of this webinar, an important part of the programme's function is to form the basis of any additional time claims that arise. Delay or critical path analysis is the forensic investigation into what has caused delay to completion of the works and can be used to attempt to assign liability among the parties. Critical path analysis identifies the different kinds of float in the programme, allowing parties to identify which activities have a knock-on effect on other activities, which activities are the most crucial to the completion of the project, and where the areas of the greatest time risk are. There are many different kinds of delay analysis methodologies, and choosing the most appropriate depends on the factual and legal circumstances, as well as the availability of evidence. Efforts to undertake this analysis are often constricted by the availability of records. and so it is very important to keep adequate records of work and progress, particularly where there is a likelihood of delay. Photographs with a time and date stamp are a particularly helpful piece of evidence. However, overall, it is important not to lose sight of the purpose to which this analysis is being carried out. In our experience, there is little benefit in undertaking complex delay analysis if this is not presented in a manner that is understandable to the decision maker. The courts have generally expressed a preference for a common sense approach and have made clear that theoretical delay analysis techniques will not be a substitute for causation in fact and in law.
It's highly unusual for the problems that materialise during construction projects to be discrete issues that do not impact on other activities in the works. Rather, it is more common for problems to be interlinked and difficult to separate. These problems are often attributable to both parties. These situations can be referred to as concurrent delay, defined as two or more delay events occurring within the same time period, each independently affecting the completion date. There are difficulties in ascertaining what remedies should be available to parties. For instance, should concurrent delays allow an extension of time and loss and expense claim, or liquidated damages and ascertained damages? The courts decide upon cases of concurrent delay very much on an individual factual basis, and therefore it is difficult to discuss hard and fast rules. To add to the complexity, there are a number of differences in approach between the Scottish and English courts. For instance, a leading English decision stated that where there were two or more effective causes of delay with equal causative potency, the contractor will be awarded an extension of time. However, the leading Scottish decision states that it may be more appropriate to apportion the delays between the parties. The practical effect of these differences is that in England, contractors may be entitled to a full extension of time but not loss and expense, whereas in Scotland, in the same factual circumstances, they may get additional time as well as some of their loss and expense. It should be noted that this is an area where the standard form is very commonly amended. For instance, parties may insert provisions in relation to what constitutes concurrency, guidance as to the identification of the dominant cause and the consequences, and perhaps the insertion of more favourable terms for the employer. This will now conclude the webinar with a roundup of some of our key tips on management of the programme and time claims.
So although it seems like a very basic point, our first tip is to make sure that a baseline programme is submitted and then refreshed to reflect the ongoing work progress. We still come up against a surprising number of disputes where this is not the case. Particularly in NEC contracts, the absence of an accepted programme can result in a lot of difficulties. In relation to extension of time claims, it is absolutely essential for parties to keep good records of the progress of the works. If these are detailed, in one place and easily accessible, if a dispute does occur, you will already be on more solid footing. Pay attention to what kind of contract you are using early on, and make note of how each type of delay will be dealt with, and what party will bear the time and cost impact. In relation to acceleration, be aware that in both JCT and NEC, the employer cannot unilaterally decide to accelerate the works, that is, in the unamended contract. The contractor is allowed to refuse to accelerate if it is not feasible for them, or if the quotation has not yet been accepted. Critical delay analysis can be a good tool for forensically assessing liability for delay. However, the courts have made it clear that they prefer a common sense and realistic approach over an excessively complicated and theoretical methodology. It is important to keep the decision maker at the forefront of your mind when considering these approaches. Lastly, if you are dealing with a situation that involves multiple delay events, it is important to be aware of the differences in approach between the Scottish and English courts. Also, it is important to know your contract, as this is a common area for amendment to the standard form.
We've now come to the end of this webinar, which we hope has been useful to you, and we still have a few minutes to answer a couple of questions. If you haven't done so already, then please type any questions you have into the box now. While you're doing that, I'd just like to take the opportunity to remind you, if you've missed the previous 2 webinars in this series on payment and variations, these are available on our website. All attendees to the webinars will now also receive an on-demand recording of the webinar to listen again or share with colleagues.
Okay, so we have had one question come in. The question is, you mentioned the differing approaches taken by English and Scottish courts in respect of concurrent delay. What were the names of those cases that you mentioned?
Okay, so yeah, that was the leading case in Scotland on concurrent delay would be the City Inn against Shepherd construction case, and that case was an inner house decision of the Court of Session. That case isn't binding on English courts, although decisions of the inner house can be persuasive. In England, the leading case is Henry Boot Construction and Malmaison Hotels, and that was a technology and construction court case. And there were actually a couple of more recently decided TCC cases in England on concurrent delay, and those were De Beers and Atos and the Walter Lilly case as well. And if any of our listeners would like a copy of any of those judgments or would like to discuss any of those cases, then please do just let us know. I think that was the last question, and our time is up today. Thank you for joining us for this webinar series, and we hope you'll join us in the new year for our top 5 construction and adjudication cases of 2019.